is disturbing. Yes. What did you say? पहले से पढ़ो from the beginning. Read from the beginning. Read from the beginning. How it starts. Full stop. Time to deposit the amount is extended. Full stop. The amount shall be deposited.
Lord, in this case, the respondent lost his job, my lord. The matter is very urgency, my lord.
He has
Honor-
dumped
honor-
all waste materials in that premise.
On or before.
Interior model ship action.
No, my lord. There is no interim order at all.
My lord, there is.
On or before 19th of May. Full stop. Failing which the
Interim model may extend, my lords.
No, interim.
No, there is no interim order at all, my lord.
failing with the execution shall proceed.
Proceed. Yes, please.
Deposit by 19th of May.
Yes, my lords.
Number 33.
Please, may I appear for the petitioner. This is the petition that relates to the Preservation of Trees Act, my lords. There is nothing urgent pending before your lordships today. Only two small points. One is there is an office noting on the cause list that I did not amend the cause title I've given them for compensatory afforestation, etc. Just on that memo, if your lordships would direct them to file a reply, because the details have to be given as to how many trees have been planted, how they are surviving, etc. 6/2/2025, they may be directed to file their reply on the next date, your lordship.
Learned Advocate Mr. Pradeep Nayak stated that all the office objections are dealt with and satisfied. Full stop. The statement is accepted. Full stop. At the request made by learned parties, 10 or 2.
Any date.
No urgency. So it will go to somewhere in July, 17th July.
Please, one request, no, it's a letter of 5th March, which I have written them to show that they are in non-compliance. If they may be kindly directed to respond to that, just so that we place the facts before you on.
What letter?
Regarding the compensatory plantation and afforestation, I had written them a letter on 5th March. May I place this?
Can you just help me by putting this
Just
file
placing
number?
the letter on record, my lords.
So compliance they have to report.
They have.
So compliance they have to report.
They have to report compliance. A BMRCL, man. This is point number 5.
For the next date, the Bombay Metro Rail Corporation, the Bangalore Metro Rail Corporation shall submit the
Would your lordships direct them to respond to my the points I have?
shall submit the compliance by responding to the letter dated 5/3/25.
Deeply
addressed by the petition.
So great.
Place on record the 10 to 18th of, not 18th, 10 to 26th of June.
Number 35. PL Mr. Prashant Rao, party in person.
The respondent number 2.
Number 35.
My lords, my senior is on his legs. Kindly pass over, my lords. My senior is held up in other court. He is on his legs. Kindly pass over. I appear for respondent number 2.
Party in person, the petition party in person is not present. Stand over to 18th of July. Full stop. Learned, not learned. The registry shall intimate. Full stop. Learned, not learned. The registry shall intimate the next date to party in person by registered ID post. Great. Next.
Serial number 36.
I'm representing petitioner, Lord.
PL.
Lord, this is a public interest litigation complaining against illegal occupation of a public park, which is measuring 1.5 acres, and rearing of pigs that is happening there, my lord. Rearing of pigs, my lord. It has become very difficult for any person to stay there even for half an hour, my lord. It is completely residential area, my lord. Admittedly, this is a residential area, my lord. And the respondent number 3, which is Tumkur City Municipal Corporation, my lord, it has already filed its statement of objection. Lordship, can kindly take up for a moment the statement of objections, my lord. The respondent number 3 has already filed a statement of objection. Lord, time frame may kindly be fixed, my lord, within 1 month or 2 months, my lord. From last 15 years, this has been going on, my lord.
Time frame for what?
They say they have been taking steps to form a separate layout and allot sites to the illegal occupants of this public park, my lord.
Where is that?
Statement of objections, which is filed by the respondent number 3, my lord. They have not denied any of the things what I have stated in my petition, my lord. A bad stench emanating from that particular place, my lord.
4th of February, my lords, 2025. 4th of February 2025, my lords, objection is filed. Where, my lords, with the assistance of, my lords, the Deputy Commissioner and other departments, the 4 acres 14 gunta, upon, my lords, the formation of the layout and providing of basic amenities and facilities. Thereafter, my lords, the squatters will be immediately shifted. I have placed on record, my lords, the details of the proceedings of the government, the Deputy Commissioner, and, my lords, the authorities.
So you are developing a new,
Layout, my lords.
and they will be
They will
standing
be shifted there.
within what time?
Lords, the time, my lords, is that because some of the, lords, the.
Lord, this
since
has been
the
going on
area
from
is-
last more than 15
we have-
years, my lord.
We have effectively taken steps.
Difference from 6 months?
Lords, the issue is, my lords, that we are, my lords,
This is nothing but rewarding illegal occupants of public park, my lord. Let them do it, my lord. Let them do it in a time frame is my respectful submission, my lord.
that we may report.
From
it, my
last
lords.
15 years, this has been going on, my lord. They have not been denying any of the things what I have stated in my writ petition, my lord.
I'm making this submission, my lords, instead of disposing of the matter. My lord, if it is called after, my lords, 8 weeks, I will be able to place on record, my lords, the further steps.
No, my
Instead
lord.
of, my lords,
Let it be disposed of by giving a,
No.
by fixing a time, my lord. Let them do whatever
that
they
may
want
not
to do, my
resolve, my
lord.
lords, his
Let
issue.
the park be evicted and it be,
No, I am saying, my lord, that
Open for
that
the
may
general
not
public,
resolve
my lord.
his issue, my lords. I am only seeking that. I am saying, my lord, that
Open for
that
the
may
general
not
public,
resolve
my lord.
his issue, my lords. I am only seeking that. Now, my lords, if
Within 8 months. You are developing a layout, no?
layout, my lords, is
it
being
can be
developed
done.
with, my lords, the assistance of the Deputy Commissioner and, my lords, the Planning
But I am
Authority,
taken
everyone.
by surprise. I have nothing. I am before my lord. There's no communication to me.
Preferably by 8 months. Preferable.
8 months.
We'll dispose it.
8 months.
We'll take note of their reply and say that preferably in 8 months, they will complete the.
not 8 months is too long time, my lord. In fact, they have said 75% of the amount is already released and it has been kept in the deputy commissioner's account, my lord. Let it be in a 2 months or
Towards what? Amount towards?
towards the formation of this layout and giving sites to them, my lord. And it is 1.5 years back, the decision, my lord.
No, that has been
We'll
released.
see 8, 6 or 8. We'll see. We'll examine the facts and leave on.
As
us.
early as possible is my respectful submission. Unless there is intervention from the court, my lord.
So we are
not
doing that. We
Public are left in
we are-
election, my lord.
We'll fix some time limit,
Yes,
6
my lord.
or 8.
Grateful, my lord.
6 or 8, depending on the facts. Yes.
So we
So
did-
next.
From 2008, they have been given representations,
We'll
my lord.
see. 6
Oh,
months.
copy nilla.
Preferable.
8 months, my lords. 8 months, my lords.
No, my
We are saying preferably.
Please,
Preferably.
please.
37 is urgent. Seal number 38. Shrimati Shweta Anand. Shrimati Shweta Anand.
The last occasion also they did not appear. But may I have it after a week, my lord.
Yeah.
This is 2011 matter.
Please, ma'am.
Appeal.
Please, ma'am. No, it's pertaining to
Oh,
public
this is
interest
very
litigation.
Pertaining to
Pension
PIL.
scheme. Pension scheme, ma'am.
Writ appeal.
Which one, madam?
Mine was not 37 was adjourned.
Who will appear?
Madam Shweta Anand and Kumar MN is appearing.
They are not there. Shall we keep it back?
We'll have it on some other day, my lord. Some other day.
Some other day. We will go to, extend over to June 24, 25.
Contempt matters. Bill number 39.
Lords,
To
appearing for
Virupaksha
the
PH.
petitioner, my lord. My lords, direction, my lords, of the honorable single judge, my lords, is to consider my representation, my lord, for redetermining, my lords, the compensation payable in favor of the petitioners. My lord, on 3/2/2025, my lords, a memo is filed, my lords, to the effect, my lords, that certain claimants, my lord, have been paid compensation. There are 8 claimants, my lord, in whose favor, my lords, compensation is yet to be released. Lordship may dispose of this contempt petition, my lords. My respectful submission, my lords. May I request your lordships to dispose of this petition, directing them, my lords, to.
There is a single complainant before my lord, serial number 4. We have dispersed it in favor of the complainant. Only one complainant is before my lord, sir.
However, my lord, the claim petition was by 35 claimants.
There are how many petitioners? 5.
There are, my lords, petitioners, my lord.
5.
5 petitioners.
So in respect of these 5, it is dispersed.
My lords, in respect of, no, my lords, in respect of 5th petitioner, it is not yet paid, my lord. In fact, on the previous,
Only one. So contempt is only by one.
my lords.
Only by one, serial
Please, my
number 4, we have dispersed the.
Please, my lord, it is by one of the claimants, my lord. However, my lords, on the last date of hearing, this honorable court had directed, my lords, the respondent accused to consider, my lords, releasing compensation in respect of the claimants. In terms of the direction, my lord, they have released the compensation, my lords, in favor of most of the claimants, my lord, except 8 claimants, my lord. My request,
Complainant is covered.
my lord, except 8 claimants, my lord. My request,
Complainant is covered, my lords. Complainant is covered in the memo
Please.
filed by us.
It is not disputed that in respect of the present contempt complainant who has filed the contempt petition, the directions of learned single judge, the directions of learned single judge, which were to learned single judge, dated in his order dated 8 September 23, which were to consider the application of the petitioner regarding payment of compensation, has been complied with, and that the compensation is paid. Full stop. In this view, the present petition, contempt petition, does not survive. The same stand disposed of. Paragraph. Learned advocate for the petitioner, however, stated that other similarly situated complaint persons are yet to receive the benefit.
please.
Full stop.
Compensation
In this regard, learned additional government advocate, Mr. Chandrasekhar, stated that all are paid.
No, only with regard to the complainant we have paid. I have annexed the memo as such, my lords.
All will treat it similarly. No, nothing doing. In that view, this will not survive, and it is disposed of. For others, you file separate contempt petition. Yes.
50 acres of land was granted to 2 persons as per Annexure C, my lord. In the year 1987, Pakka Podi and Haddubast was not done. Therefore, representations were given.
We have issued the endorsement, my lords.
My lord,
Now the correctness of the endorsement is
the
being
en-
challenged.
And
My lords, complaints affidavit, annexure R1, page 8, my lords. The reasoning is at page 11, last paragraph, my lords.
Where is your compliance?
My lords, we have told that with regard to the grant condition, there's been violation. So there should be modification of the extent of grant. Hence, for the present, the Podi and Duras can't be considered. On 8th, we have issued the endorsement to the complainant. On 10th, it's been addressed to the regional commissioner, my lords, for revising the grant extent as such, my lords.
My lord,
If they are aggrieved, they have to challenge the endorsement
after
given
the
as such.
grant, my lord, after the grant and after several representations, they have not taken steps to fix the Haddubast. When I approach this honorable court and court gives a direction They say that to that extent I am agreeable. Let them fix, that extent I am agreeable. Let them fix the Haddubast because the grant is of the year 1987. Now they say that extent appears to be less. They measured it, it's what they say. To that lesser extent, let them fix the Haddubast. That they don't do. Kindly see page 13 of the affidavit filed by the petitioner. It is their document. They say that it is the extent is given there. That is in the year 80s, 2022. In the year 2022, they issue a notice to me. Revenue inspector was there. Other revenue authorities were present at the spot, and it was measured at annexure R2.
So what do you want now?
My lord, it's my humble request. They say that it is lesser in extent. To the lesser in extent which is found, let there be a Haddubast. Let them mark it. Let them mark it and fix the Haddubast. The report is at annexure. The report is at annexure 2. It is by the surveyor on 6/5/2022. This says, now in Kannada it says that the extent is in one block as against 25 acres, it is found to be 23.24. Kindly see page 13, my lord. Okay. Kindly see page 13, my lord. One is.
I will do it again, you do again.
My lords, let them say that they are not agreed with the endorsement and give a representation. We are bound to do the same, my lords.
Fair enough.
Lord, from 87
They have to agree that
onwards,
our endorsement is right in his.
But the whole idea is to cancel this.
This is not a writ jurisdiction, this is contempt jurisdiction. That is the whole problem. You are both, all of you are mixing up while arguing.
But look at the reasoning and the attitude and what they have placed before this honorable court. Annexure 2 is their survey. According to that survey, let them.
Learned single judge directed in his order dated. It is stated by relying on a circular of the state government. That as per the state government circular, dated 23/6/2012, after amendment in the act, the direction for Podi and Durasti would be given only subsequently, and that there is no provision for Pakka Podi of 50 acres. Full stop. Any of the above endorsement? The directions could be said to be complied with as the representations are considered.
My lords, there was a specific direction for me to file a further affidavit, my lords. I'm awaiting instructions, my lords. Certain documents were produced. Short time, I will file the same.
Order to enable learned additional government advocate, Mr. Navin Chandrasekhar, to file further affidavit, send over to 19th June.
Can it be little earlier, my lords? It's about, my lords, adding new classes to the existing institution.
if the academic year will begin, my lords, by June. My lords, in the first week, if my lords, is possible.
So this is for what?
My lord, it is about, my lords, for upgradation of the existing institution for having, my lords, additional classes. Instead of 19th, my lords, if it is immediately on reopening, my lords, if the matter can be taken.
6th of June.
Obliged.
So for number 43, Mr. B.R. Vishwanath.
That's compliance affidavit has been filed, my lords.
I have not received.
Endorsement has been issued, my lords, on
I have not received any copy of.
12/20.
I'll go through it, my lord, and make my submissions next week.
We have filed our compliance affidavit, my
Where is
lords. The endorsement is at page 12.
Calculated and included my extent also in survey number 19, and a common award has been passed, my lord. So now the identity of my land and the extent of my land, what are all the trees that have been acquired in my survey number, that was not specifically mentioned. That's why, my lord, I approached this honorable court to seeking a direction to say that, my lord, what extent of my survey number 19/2 has been acquired, what are all the trees that have been taken from my land. But again, my lord, they say that they have passed an award to the extent of survey number 19. Survey number 19 is a larger extent owned by 41 people. Passing a common award pertaining to entire survey number which does not owned by me, my lord, they are trying to interfere with my survey number. That was the specific direction that was prayed for before the honorable bench, my lord. That was accordingly granted. That has not been complied. Again, they have come up with the same story saying that, my lord, award has been passed. My specific grievance before the learned single judge was that, my lord, my identity of my survey number has not been mentioned. What extent is being taken over, that has also not been mentioned. Again, my lord, the same endorsement they issue.
Paragraph 4
Where is
and 5
the
is the,
endorsement?
my lords, paragraph 4 and 5 is the direction of this honorable court.
That we have seen. Where is your endorsement?
Endorsement is at page 11 of the affidavit, my lords. Page 13 may be seen, my lords. We have issued notice. We have sought for documents.
So dispose it of.
Yes.
Nothing to write.
May. This again, my lord, that's the same mistake they have been doing. When once, my lord, a survey number 19 was bifurcated, coded in 1900 itself, my lord, notifying. I had submitted a representation, my lord. One. Restriction, restriction order. Either. Sorry, my lord.
Well, let's find out 2/3. Next.
Number 44, Mr. Sudhindra S.A.
They have filed the affidavits, but the directions given by this honorable court are not fully complied.
Lords, there are 3 folds of
Let
directions.
this matter be taken up after vacation so that they will get little time to
The order.
do better.
It's been
7th June.
Order is fully complied.
No, not.
No, he can point.
Under the contempt jurisdiction. He stated that office of the will be removed within
10 days, my lords, I'll
days
complete.
from today, and the appropriate order shall be obtained. Full stop. In accordance with law, obtained from the competent court. In that view, the present contempt proceedings are adjourned to 12th of June.
By then I'll do it, my lords. I'll get it listed.
12 June, your lordship.
47 also.
47 also same, your lordship.
46.
Which one?
47 is
47 also, my lord.
47 is also same.
order.
2023 is the order, more than 1.5 year, my lord.
We'll do it. I'll do it, my lords.
Under the guise of pendency of the appeal, my lord, which has not been complied, my lord, we are put to trouble, your lordship.
Appeal is already filed, my
There
lords.
is a clear government direction, my lord.
No, they will do it.
Number 46, Mr. R.B. Sudhashivappa.
Lords, this matter, my lords, I pray for a week's time, my lords, to report the status of compliance, my lord. Direction was issued, my lords, to execute a deed of reconveyance, my lords. Lords, now the problem is, my lords, based on a spot inspection, my lords, it has come to our knowledge that, my lords, a third party is in possession and has constructed a 3-storied building, my lords. That was not brought to the notice of the learned single judge.
I'll affidavit.
Please.
Stand out 18th of June.
Please.
18th is not. 18th.
Obliged.
57 is adjourned. Number 48, Mr. Venkatesh T.S.
It will little earlier because my own site, my lord, they are not executing the possession sale deed in my favor as per the direction.
6th of June.
Please.
Great.
Number 48, Mr. Venkatesh T.S.
The writ appeals are pending, your lordship. They're listed at serial number 76 today.
Stand out.
Can all be taken up together.
20th.
63 also.
20th. Yes.
63.
17th.
Was WA 1339 of 24. It's pending.
Which is number?
1339 of 24.
In view of the pendency of writ appeal number 1339 of 2024, the present contempt proceedings are adjourned to 8 July.
Great.
None is present with the complainant.
8 July. 51, 52 are adjourned. Number 53, Mr. Mallikarjun G. Contractor. Number 53.
None is present. Stand over to 9th July.
Number 54.
Sit for some time minutes in this matter.
Pardon?
Lord, second week of June minutes.
Stand over to 19th June as requested by learned advocate, learned additional government advocate, Sri Nilokar. Learned additional government advocate, Sri Nilokar.
19th June. Cell number 55, Mr.
Hearing complainant, my lord.
K.
For accused moment, kindly pass over, my lordship. We'll file a
Pass or not? 8th July.
Cell number 56, Mr. Satish K.
Lords, in this matter, we are filing SLP, my
6
lords.
June. 6 June.
I'm appearing for complainant, madam.
Lords, we are filing SLP in this matter, my lords. GO has been issued.
Which one? Serial number?
56, my lords.
What do you want?
Want some time, my lords? We are filing SLP.
The request of learned additional government advocates, Nilokar would stand over to 14th July.
Number 57.
Writ
Yes,
appeal
Lakshmi
has been
Narayan.
filed, my lords, and it is listed on 28/4 minutes.
For the complaint, madam.
Appeal.
Writ appeal has been filed and listed on
It was stated
Filed and
on
writ
the
appeal, my lord, it is for
P69
office
of-
objection.
State that
My submission, my
writ
lord.
appeal is filed and is the same is slated to be posted on.
Now they have filed a writ appeal, prolonging the matter only because of there is a office objection.
It's listed on
Less than 28, my lord.
28/4/2020.
Maybe tagged along, my lord, and
To be
taken.
listed on 28th along with the writ appeal.
369 of 2025, my lords. Writ appeal. now.
16 and 2010.
Much of.
So 58 is adjourned. Cell number 59, Mr. Devraj K.S.
Lord, in my respectful submission, my lord, kindly see the page at page 11, my lord. Lord, my submission, there is a gross contempt of this court, the deliberate attitude. But the respondents 1 and 2, my lord, they are my neighbors. Lord, I am a religious institution. The respondents 1 and 2, my lord, started construction without leaving any setback. I filed a civil suit. Injunction was refused.
I came before this honorable court, and this is the order passed, my lord, by this honorable court on, my lord, 28 November 2023, page number 11, my lord.
So we interim order.
Yes, ma'am. Now, kindly see next paragraph 2, my lord. Respondents are restrained from putting up any construction towards the eastern side of the suit schedule property. Now, what has happened is, in the schedule, I had shown the respondent's property as a scheduled property. It should have been to the western side, because kindly see the plaint, my lord. Your lordship see the plaint schedule at page number 21. Page 21 is the schedule. The western side is the complainant's property. But he is all along is aware where I am situated and where he is situated, where his building is situated. Now, taking advantage of this small mistake, he constructed the entire floor. Kindly see page 59, my lord. May I draw your lordship's attention to
Where
page.
should we enter here? The order, contempt jurisdiction.
Now, this order, no, this order is modified now. This order is modified by this honorable court on the application filed by us. It is clarified that it is to the eastern side of the building. In spite of that, what he has done is, when we filed the MFA, may pass on with lordship's kind permission. When we filed the MFA and when the interim order was granted, he was at the ground floor. Now, despite the order of this honorable court, he proceeded with the construction and completed the entire construction as on today. Completed the entire construction as on today. Kindly see page 11. Page 11. This court has ordered that the respondents are restrained from putting up any construction towards the eastern side of the scheduled property. So and so for the appellant submits that the plaintiff property is situated to the western side as per schedule mentioned in the plaint in so and so. Therefore, he prays for rectification of the order dated so and so. It is further submitted the respondents are putting up construction toward the western side on the base that the interim order of restraining the respondent from putting up the construction is on the eastern side. Therefore, what the relief sought by the learned counsel for the appellant is restraining the respondent of putting up the construction to the western side, but not eastern side. Therefore, the order dated 28/11/2020.
Mr. We are not entertaining. Heard learned advocate Mr. So and so, the complainant, and learned advocate Mr. the respondent. The order which is brought under the contempt jurisdiction.
Can I make one more
contempt of court 1971 is order dated 28 November 2023, passed in the pending proceedings of writ petition number full stop the interim order which was to operate was until the next date of hearing. Full stop the proceedings are stated to be adjourned from time to time before the court taking up the miscellaneous first appeals. Not only that, in course of the hearing today, it was submitted, it was undisputedly submitted that the order dated 28 November 23 has been subjected to modification.
Yes,
by
they've
the
already
court
filed
concern also. Also in the in the aforesaid view, more particularly when the order is interim order, this court is not inclined to exercise its contempt jurisdiction, relegating the parties to work out its rights and their rights and remedies before the proceedings of miscellaneous first appeal pending before the court concerned. With the aforesaid observations and without going into any aspect of merit, the contempt petition is disposed of.
But even after the order of this court,
normally not entertaining. Yes.
Number 60, shall we add up?
60. Go to 18th of July. 60.
Number 61, Mr. Vijay Kumar K.
For the complainant in this matter. The respondents are not complete the order dated.
Who appears?
The complaints is at the hands of BBNP, my lord.
Nobody is there. Wait. Interrogation. Immediately.
Date may be fixed, ma'am.
Immediately. 10th of June. Learned respondent was not present. Learned petitioner was present.
So number 62.
No,
I appear for the complainant in this matter.
Yes.
I approve for the complainant in this matter, my lord. Order passed by the learned single judge of this honorable court is at page.
Where is the order?
Page 52, my lord.
Page 52.
Please.
Yes.
No, no.
Directed to consider the application.
Peruse that endorsement, my lord. They have neither complied it nor closed it. Page 15, my lord. It commences from page 13 of their affidavit.
You decide. What is the word decide?
Paragraph 4, page 3, my lords.
Consider the application and to needful.
Please, ma'am.
My lords, it comes within the 18-kilometer radius. So we have written for action under, for cancellation of grant under section 108K, my lords. Hence, we have rejected the application for conducting podi and duress, my lords. So the same endorsement has been issued to the.
No, my lord, they have not rejected you. Lordship, may kindly peruse, my lord. Page number 15, my lord, operative portion. Page 14, my lord. Accordingly, the representation submitted to this office has been allowed, and the proposal has been submitted to the Assistant Commissioner Bangalore North Taluk as in reference number so and so, requesting to take action under Rule 108K of the Karnataka Land Revenue Act rules as per the recent government circular pertaining to undertaking podi to land in land measuring 1 acre 18 guntas in such Hesraghatta Hobbli. Hence, your representation seeking podi durasti is proposed proposed land measuring
Dated 21st February 24, the petition was disposed of by learned single judge.
has been allowed.
Granting liberty to petition to file an application online to the respondent Tehsildar. Full stop. The Tehsildar was in turn directed. Tehsildar in turn was directed to consider the application of the petitioner and do the needful. Full stop. When the non-compliance of the above directions was alleged, respondent appeared and filed compliance affidavit along with which endorsement dated
2/8/2024.
And
2024 is
they again
produced.
say, I'm sorry for the
Passed
interruption.
by Tehsildar. Full stop. As proceedings are not required to be continued any further. However, the petitioner shall be at liberty to take recourse of law and avail its remedies as may be advised against the endorsement and the action reflected on part of the respondents. This court, however, does not express anything or merits in that regard. The contempt proceedings are accordingly closed.
My lord, in this application also, my lord, they say you are informed that action will be taken as per orders of the High Court of
File
High Court.
seek
My
a
lord,
writ
in
of
reference-
mandamus.
Please, my lord, they have not complied the order, my lord.
Nothing.
In similar manner.
63, 64 are urgent. Seal number 65 to BVM Adekar.
We have complied, my lord. We have complied and we have sought for Form 3 to be submitted by the complainant, my lord. 10/12/2024, we have issued the endorsement. Form 3 has to be submitted. So we have sought for Form 3, my lord.
So in that, you acted in their favor.
My lord,
You acted in favor of the petitioner.
further prescribed format in Form 3 has to be submitted, my lord. Sought for the same, my lord.
Wait to 2:30.
Very much, my lord.
Keep it back. What is the controversy?
I never, my lord, encroached any of the park or CS site.
What is the controversy? Encroachment.
They, my lord, according to them, it is an encroachment. 21 sites are there. 21, my lord, the PA and parks are there.
Why do you
Somebody has
worry?
encroached.
Why do you worry for time then?
Please, my lord.
21st July.
Because I am paying, my lord, interest to the bank, that's the reason. Early date.
Why do you worry for a time? You are not the petitioner.
My lord, I am the respondent affected party, my lord. I've been,
No, any interim order is operated.
there is an interim order, my lord, therefore, and I could not able to put up the construction, my lord. I raised a loan from the bank. And she is, my lord, the bank employee.
12th June.
Please.
Seal number 67, Mr. Ashwath Narayan Reddy, petition PL.
That my senior counsel today is not feeling well. Please, 1 week
Not
time may
feeling
be
well.
granted.
Learned advocate Ms. So and so requested for time on the ground that the senior counsel who wished to appear with her is not 12. Full stop. Stand over to 22nd, 3rd of July. Comma as requested.
Seal number 68, to Venkatesh Sumareddy, CPA.
My lord, I appear
Pleading
for
applicants.
the first respondent, my lord, on the last date of hearing, my lord, I directed the government, my lord, to take action against, my lord, all those persons who were in occupation of Gram Panchayat shops, my lord, and they were paying minimal rent. My lord, I have received some reports which are in Kannada. If my lord could have it immediately after vacation, I will file them. My lord.
Stand over to 30th June.
Obliged.
Seal number 69, Mr. Raghavendra G. Gayatri.
Your Lord, this may have to be adjourned because the learned single judge's order, my lord.
Lords have heard of inquiries handed by the government, not by the board. And my lords, learned single judge interferes on the ground of inimical bias. The lords had said, my lords, it will let it come after disposal of writ appeal 19 of 2025.
Disposal.
No, it is not yet released. 19 of 2025 is still reserved for orders.
Learned Advocate Mr.
Sridhar.
Sridhar states that the writ appeal number 19 of 2024 is awaited its
19 of 2025 is reserved.
Is awaited its final outcome.
Lords,
in that view,
subject to my lords, may I say one submission? My lords, they have filed the intra-court appeal on the ground that, my lord, they have seeking interestment to themselves as well. It is a request, not tenor is not mandatory in nature. Same argument was placed before, placed in writ appeal, intra-court appeal 19 of 2025, when it is said it is not them asking request for themselves. Lords, that would be against the order of the coordinate bench of this honorable court in 55904 of 15.
what do you want?
Lords, all that I say is, my lords, that with respect to inimical bias, there may be liberty reserved for me to argue on that also.
You argue on all points. Which date? After vacation.
Subject to
26th of June.
Obliged.
All arguments are permissible to be, all submissions are open to be argued by both the sides in relation to subject.
Prosecution, we are filing IF for leave. During the course of the day, we'll file it. Prosecution, we are filing IF for leave. During the course of the day, we'll file it, my lord.
What IA?
My lord, the appellants who are not party before the writ petition, my lord.
All right. Learned Advocate for the appellant wants to file IA. Stand over to 29th of July. Yes.
Seal number 74, Mr. Nagaraj D. 74.
None is present. Stand over to 24th of July.
This is furnishing of process fee, etc. Seal number 75, Mr. Abhishek K.
All 2 weeks, 75, 76. 2 weeks time is granted to take necessary steps. 75, 76.
Seal number 77, office objections with.
So 77, 78. 4 weeks time is granted to remove the office objection, failing with the appeal shall stand dismissed automatically without reference to or order of the court. Same order in 79.
Serial number 79. There are only few minors office objections.
80 and 81.
85 or 25.
85 to baki. 80.
Seal number 80, office objection with counsel submission.
Kindly pass on. Pass on, because
Passing or not possible.
Pass over.
Advocate.
pass over, my lord.
Passing or not possible. 14th of July. Next.
Seal number 81.
I appear for
Ajay
the
Kumar Patil.
complainant. I have
Which
made certain
objections are-
persons who are not parties. I will not press for them. Notice may be ordered to 1 and 2 who are parties.
Office objections are dispensed.
Office objection is that I have made certain persons who are not parties to the writ petition.
So
As
objections are dispensed with for the time being. The contempt petition may be listed on 9th of.
notice may be ordered to 1 and 2, my lord, who are parties.
Next.
1 and 2.
Next.
Seal number 82, Mr. Virendra Sharma R. Office objection with counsel submission.
None is present. Office objection will be dispensed with on or before 12th of June, failing with the petition shall automatically dismiss without reference to or order of the court. Yes, next.
Number 83. Mr.
Your Lordship,
Shimala
I appeal for
Nagaland.
appellant, my Lordship. The office objection was to produce annexures C1 to C4, but the writ petition was with respect to just one single writ petition, my Lord. So we not produce the rest of the writ petitioners annexures. The depositions, rest of the things were not produced in writ petition. So same was not produced in writ.
Office observations
Were not produced in writ petition. So same was not produced in writ.
office observations are dispensed with. The appeal may be listed on
Your Lordship, the matter is coming on 24th, the connected matters, my Lord.
24th of June.
24th, my Lords.
Not possible.
Final hearing matter, seal number 84.
Appear for the appellant. This is that matter relating to the Inams abolition.
So we'll be able to complete
Yes,
before.
I won't take more than 10 minutes.
We are in rejoinder.
Rejoinder.
He's replying, my lord. All of us have finished. He's giving a reply to my article.
Rejoinder.
That's correct.
Rejoinder.
Shouldn't take much time.
I won't take.
Now there is a section, which section? Now there is a section, which section?
Give me the act.
Yes.
Kemper Raju, my lord. That Kemper Raju, who, my lord, was the petitioner before the learned single judge, had not made any application as is required under the Inams Abolition Act at any point in time. In no proceeding, my lord, prior to the year 2000, does his name figure in any of the proceedings.
Yes.
Kemparaju's name, my lord, though the
By Kemparaju.
no application by Kemparaju at all. As your lordships were pleased to notice, he made an application for impleadment, not an application for regrant of lands. Impleadment as a respondent in some other proceedings, which is what the land tribunal says, it does not exist. To which, my lord, my learned friend argued, saying there is a certain document which are lost in a fire accident, and that therefore Kemparaju is not there, no? Kemparaju is not there. And my learned friend placed before my lord one order of the Karnataka High Court, a learned single judge's order, on 21st September 1994, directing reconstruction of the records.
Who directed?
Beg your pardon, my lord?
Who directed reconstruction?
This honorable court, my learned friend placed before my lord an order dated 21st September 1994.
Yes. Yes.
To get around the difficulty that no application by Kempai Raju is before the land tribunal, for the first time an argument was advanced before the learned single judge that there is a destruction of records in the land tribunal, and therefore my application may have been lost or destroyed. Never raised, not till this proceedings were initiated before the learned single judge. an application implement in 2000. There is an order, my lord, which they had handed over to your lordships last time. I don't know if my lord has it. It's in writ petition 24912. You filed to the memo, sir, or just give it? Memo, right?
That is part of the record.
No problem. I'm saying how you filed it, with a memo or without a memo?
With a memo.
So have been destroyed.
By this court. By this court.
All it says, please see page 5.
It is ordered dated 24
September 1994.
or 29.
21st September 94, my lord. That's the first page. I think certified copy is 29.9.
Oh, 35.
To argue that there was a reconstruction of records or a requirement to find missing records, in my humble submission, is completely misconstrued in this case. The first time Kemparaju came into the picture is when he made an application to implead himself in the year 2000, and only for impleadment, nothing else.
$2,000.
2000. And my lord, I had placed the order of the KAT before my lord last time. I won't trouble your lordships again, where the KAT notices that he may be necessary to be heard. And this honorable court, my lord, in a further challenge says, no right of his has been upheld by virtue of this order. Merely because he has been allowed to be impleaded, this honorable court, my lord, says itself will not be a ground that is entitled to any relief in the proceedings. And therefore, the absence of the application in my humble submission is a complete answer to his claim. That is first. The second point, my lord, which he made is, there was an order of attachment by a court in the year 1953. And therefore, Kempaiah could not have purchased the property in 1956 because there was an order of attachment. Respectfully prevent a person from alienating the property, but if the property is alienated, as against him, it is not a defense. That is, my lord, what section 64 of the CPC says. I want to place one authority before my lord. In my lord, the judgment of the Supreme Court, in Balakrishna Gupta's case, may I humbly request, para 30, page 192, my lord. And I may humbly request, my lord, to kindly look at the bottom of the page. Bottom of para 30, my lord, about 3 lines from the bottom.
13.
30. Para 30, page 192. Last 4 lines it says section 64. Section 64 of the Code of Civil Procedure states that where an attachment of a property is made, any private transfer, I'm sorry, my lord, therein, and any payment to the judgment debtor of any debt, dividends, or other monies, contrary to such attachment, shall be void as against all claims enforceable under the attachment. What is forbidden under section 64 of the Code of Civil Procedure is a private transfer by the judgment debtor of the property attached contrary to the attachment, that is, contrary to the claims of the decree holder under the decree for realization of which the attachment is effected. And the next line, Lord, in my humble submission is important. A private transfer under section 64 is not absolutely void. That is, void against all the world, but void only as against the claims enforceable under the attachment. Therefore, my lord, it is not an absolutely void scenario. a private transfer is permissible, but it would be void against the person who has the attachment and nothing more. Therefore, the transfer in favor of Kempaiah, my lord, was valid. Had, my lord, the 11/1959 order notification not come into existence, whereby all claims, attachments, everything were dissolved, and straight away, my lord, property became the property of the government, one argument of this kind is possible by Kemparaju in a civil proceeding. But once the property vested in the government by virtue of operation of law, all claims, including an order of attachment, dissolved, which is what your lordship saw as section 3 of, my lord, the Inams Abolition Act. I'll just show your lordships that one clause.
There is another section also, 18 or so.
Yes, my lord.
That nullified your arguments.
No, it doesn't, my lord. I'll show your lordships that. Please see section 3 first, my lord. And then I'll show your lordships section, I think, 14. No?
14. First 3, let us see.
3, my lord.
Consequence of
Vesting of an inam in the state.
3F.
3F. Vesting of an inam in the state.
3F.
3F. No such inam shall be liable to attachment or sale in execution of any decree or other process of this court, and any attachment existing on the date of vesting or any order for attachment passed before such date in respect to such inam shall, subject to section 70, that is mortgage, cease to be in force. Only limitation section 73 of the Transfer Property Act. Now, not please see section 14, what it covers. Where my lord has that? My lords have that? 14, my lord. Where before the date of vesting, I'm sorry, an inamdar has created any right in any land which vests in the state other than land registered under section 709, including rights in any forest, mines or minerals, quarry, fishery or ferries, the transaction shall be deemed to be valid, and all rights and obligations arising thereunder on or after the date of vesting shall be enforceable by or against the government, provided that the transaction is not void or illegal under any law for the time being in force. Provided also, where such right was created in any land, unless it relates to land registered under section 709, the government may, so and so, my lord. Then, my lord, may kindly see section 24, my lord, of the Act. Even, my lord, where there's a mortgage, the applications of secured creditors referred to in section 21 decide the amount to which each creditor is entitled, and the person or persons out of whose share of shares of the compensation such amount should be paid. Then 2, and that's, my lord, answer to even a mortgage. Even where a right is created in the property in terms of section 14, the amount of compensation payable by the government to secured creditors on account of holding any mortgage or charge, notwithstanding anything contained in any law for the time being in force, shall not exceed the amount of compensation payable in respect to the inam or portion thereof. Therefore, if, my lord, a creditor comes and says, I have a mortgage on this property, the only right that he'll have is for the amount of compensation that has to be paid, nothing more. Therefore, this is not a scenario, my lord, where one can say section 3 runs contrary to section 14. Section 3F, in my humble submission, my lord, is a consequence of property vesting in the state. Section 24 deals with a claim, even of a creditor, limited to the amount of compensation to be paid under section 24 of the Act, and nothing more than that. His claim does not go, otherwise, my lord, it will become a scenario where one person will come and say, I have given this property on mortgage to someone else. Therefore, the property can't go in vest with the government. That, Lord, is not the intention of this Act. The Act intended always that once the notification is issued under section 1, the property vests with the government free of all encumbrances. Encumbrances not include an order of attachment to the court. And then once the property vests in the government, anyone who is interested can make an application. That application will then be considered on the merits. Yeah. Pass on, Lord, one judgment to the High Court.
Which is the section you relied on, Mr.?
14. Which section did you examine, sir?
14.
14.
14. Please see 14 itself, my lord, and see the language in 14.
Inamdar has created any right.
Inamdar has to have created a right. In this case, the Inamdar did not create any right. My lord, if I may humbly say so, it has to be some right of the nature mentioned there. Create a right in forests, mines and minerals, quarries, fisheries, ferries. It specifies the rights. Otherwise, my lord, the mortgage will result in the property going out of the entire act itself. Simply because I mortgage the property, I've created right in the property. But the mortgage dissolves because of operation of law under section 3, which is why under section 24, even a mortgagee can only make a claim for money, not for the property. He does not have a right not to make a claim as if he is an inamdar. He cannot make an application saying, now give me the property, I'm the mortgager or the mortgagee of the property.
Only to the extent of his claim.
Only to the extent of the money and nothing more. This judgment not answers that question, which I just handed over, my lord, His Lordship Justice Shantanu Gowda as then was. I just handed over, my lord, His Lordship Justice Shantanu Gowda as then was. Para?
Yes.
Clause F of section 3(1), I'm sorry, my lord has, of Inams Abolition Act further makes it clear, such inams shall not be liable to attachment or sale in execution of any decree or other process of any court, and any attachment existing on the day of vesting or any order of attachment passed before such date in respect of such inam shall, and such debt in respect of the inam shall cease to be in force. Thus it is clear that the existing attachment for non-payment of land revenue by the inamdars as on the date of vesting cease to be in force from the date of vesting. Areas of land revenue as on the date of vesting shall have to be recovered from the inamdars by deducting the said amount from out of the compensation to be payable by inamdars by the state government as per section 3(1)(c) of Inams Abolition Act. Consequently, land vests in the government free of from all encumbrances. The next two lines I'll just read. In other words, the property in question would be the property of the state government from the date of vesting, free from all encumbrances. Consequently, state government could not have sold the land in question in public auction for recovery of the areas of land revenue after the date of vesting. Thus, the auction sale conducted by state government, in which the first defendant had purchased the land in question, is ab initio void. Since the first defendant did not get any right over the property in question in person of the sale, subsequent sale made in favor of so and so by the first defendant is also void, and therefore the defendant 3 to 22 also have got no tie. Not that I succeeded before the land tribunal. Not that I succeeded before the land tribunal. I challenge the order only for one limited issue, and that is, and if I may point out, I'll just pass on the writ petition, Lord, which I had filed. I had not challenged the order for anything else other than one portion which said the land tribunal itself determined what is my entitlement. The argument of the other side was you had filed a writ petition. Since that writ petition has been disposed of, you have not challenged that order and therefore you cannot come here. Respectively, not that issue was completely different. Matter has now been remanded on other questions, and in this question he has been granted a right. Please see para 16, not last prayer. Page 16, last prayer. Issue prayer B, my lord. Issue a writ in the nature of certiorari, quashing the impugned order passed by respondent number 1, insofar as determining that the occupancy right of the first petitioner is limited only 54 acres of the land, and in the consequential direction to Tashildar to take necessary action for resumption of land, making entries in the revenue records as government. That's all. I was entitled.
Tribunal's order at page 237, in page 237, annexure K.
Yes. Yes. Insofar as.
Insofar as the claim of the fifth petitioner, your lordship gets it? The C. Kemparaju made an application on 18/10/2000, a categorical admission by the land tribunal that I have made an application. My learned friend says no application is made at all. The only reason for it is claimed it is barred by limitation. My application, filing an application.
Insofar as the claim of number 5. You claim to.
The only application which is there is an application for impleading, nothing else. My learned friend Lord now says, no, that is the application. But in my humble submission, there is no such application. And why is then my learned friend referring to an order of this honorable court asking for finding the records of the year 1984? If it was in 1994, it has no relevance whatsoever. Then a single judge also says that application must have been lost, and therefore there's a direction to reconstruct records. If in 2000 is when he made the application, really, my lord, as he says now, then why would anyone refer to an order? If in 2000 is when he made the application, really, my lord, as he says now, then why would anyone refer to an order of 1994 to say the records of that time had to be reconstructed? I'm responding to a question of his lordship, not your question, sir.
Your lordship may kindly see, I am the fifth respondent in the case. So clearly says I am the fifth petitioner. The order clearly states that I have made an application. Now it can't be gone into saying that no application is made. This is not an impleading application that was filed before the tribunal. It was filed in the writ petition. Now the second point that he would contend is section 64. I say that it is void. He refers to the decision of this court. Section 30. The date of attachment is on 31/8/53.
31/8.
53. 31/8/1953. The sale in his favor is on 26/1956. The attachment was in force. Now, your lordship may kindly say, my learned friend referred to the decision, that is Ramai Setti. The Ramai Setti, just now he referred to it and he read para 13 of the judgment. May I read the para 13, my lord? Clear that such inam shall not be liable to the attachment or sale in execution of any decree or other course of court, and the attachment existing on the date of vesting or any order of the attachment passed before such date in respect of such inam shall and such date respect of the inam shall cease to be enforced. What is the date it shall cease to be enforced? Your lordship may kindly see. Thus, your lordship, the finding of the court. Thus, it is clear that the existing attachment for non-payment of land revenue by the inamdars as on the date of vested ceases to be enforced from the date of vesting. So the attachment was enforced up to the date of vesting, even assuming that he was considered to be a debtor. The effect of the vesting is 1959. If your lordship sees, assuming my learned friend's argument is taken as correct, 53 to 59, the attachment was enforced. When the attached section 64 of the CPC says when the attachment is enforced, any private alienation is void. His sale to the extent of 160 acres is void on the date he purchased the property. So he could not have made an application in respect of 160 acres of land for re-grant because he did not have any right at all. The next question, my learned friend said, no, I have filed a writ petition challenging only the portion of the grant that was made. It should have been granted the entire, so the writ petition. But he forgets to see that same order was challenged by me in the writ petition, petition number 27,409 of 2017. I have challenged my rule. It is in my writ petition was also taken into consideration. The learned single judge has come to the conclusion that I have made an application. I'm entitled to 160 acres of land in lieu of his sale in favor of him. 160 acres is being void. As such, now he has to show on the date of sale, his document was good. What is the material have shown it? Section 64 is very clear. In fact, I have cited a decision. The moment the attachment takes place, the possession of the property goes into the hands of the court.
You will file the synopsis day after.
Day after we file.
So we'll keep it day after, and on that they will.
No.
So we'll keep it day after, and on that they will.
No, I don't think that keeping the, he can pass on the.
You can hand it over to your lordships.
Resolve.
I have already filed a.
Lord, may I just make one submission, my Lord? My Lord, I am for R26.
Now
They have no role.
After
Lord, in this.
recess.
No,
They
no,
have made any claim so far as they are concerned at all. Nothing. Only against Kemparaju is this issue. No one else.
Lord, I am for R26. I am unconnected with this dispute. As far as it is restricted only to what is stated between the parties, I have no objection, my Lord. But my appearance may be noted, my Lord, in this matter.
Yes,
That's all.
definitely.
R26.
And standard order.
May I make small?
Heard so and so at length. Learned party stated that they argued the appeal finally. They further stated that the pleadings are over and no further are required to be added or supplemented, reserved for judgment. By tomorrow, day after tomorrow, we'll give.
Day after, I'll hand over the submissions to.
2:30. May I make small?
File amended course.
2:30.
Confirm, huh?